The charges are not in place, they're stayed. So the criminal code indicates that the proceedings are at an end. But the Crown has a right within the next year to reinitiate the prosecution, to bring it back before the court, should they choose to do so without laying further charges. If at the end of that year they have not done so, then the stay becomes a permanent stay, and in fact, according to the language of the criminal code, the charges are deemed never to have been laid. The Crown wasn't even here today, as you know, the Crown who's assigned to the case. So in terms of transparency, in terms of accountability to the public, in terms of accountability to my client, at least at this stage, the Crown's chosen not to give any explanation at all as to why they've stayed those charges.
Your client's reaction?
Well, my client's obviously pleased that the criminal charges are at an end. We've always maintained that there was no basis to charge him in the first place. So from that perspective, today is a good day for him. But at the same time, as you heard me say in court, it's with the caveat that they're stayed for now. We're not prosecuting the case for now. So that's still going to be hanging over his head over the next year. And until the Crown confirms, should they choose to, they're not even required to, should they just confirm that they will not proceed with any criminal prosecution.
Is he part of the parallel investigation under the Elections Act?
Well, you heard last time that when Mr. Brewer was here on the behalf of the Public Prosecution Service of Canada, he is the one who mentioned the fact that there's an ongoing Elections Act investigation. He indicated it arose from the same circumstances and it might have some effect or impact on the case proceeding. I can tell you there's no Elections Act charges that I'm aware of at this point in time, and the question of what's going on with those issues are really for the Crown, not for me.
What do you think is going on, though? I mean, it sounds like a bit like Keystone Cops and bobbled and
well, it sounds
problematic.
It seems pretty clear today that what happened in light of the stay of proceedings today, that the decision to proceed with criminal charges was done prematurely. It was done in circumstances where they had not either fully investigated the matter or fully considered whether or not this could meet the threshold for a criminal charge. It's the only explanation I can assume or gather from the fact that the charges were stayed today. So I'm not going to say it's Keystone Cops or, you know, this is a function of the right hand not knowing what the left hand is doing, but you can draw your own conclusions. The charges were before the court. We were always anxious to proceed. The Crown was the one who said, well, wait a second, we may not be ready to go ahead. And sure enough, today they've stayed the charges to either buy themselves more time to investigate the matter or because they realize that in fact this was not criminal conduct. My client has been a long-serving and contributing member of the Sudbury community and the northern community. He has done tremendous things for this community, as you all know. And certainly when you get charged criminally, it can't help but have some effect on your reputation. But I trust and he trusts that the people of Sudbury who actually are knowledgeable about his contributions, who appreciate today that the charge against him, the criminal proceeding has come to an end today as against him, that they will not hold the fact that the police chose to charge him against him. He's not the one who opted out of the trial here. It's the Crown who said, we're not proceeding, we're not ready to go, we need to stay the charges against you. Sure, it has an effect on his reputation, but he's done so much for this community. Hopefully the people of Sudbury can look beyond the fact that the police chose to charge him.